Ms. Guajardo did, the client did get a change of status, became allowed into the United States, and that part of the case got resolved. So that's a situation where we're dealing with rule number 15D, declining or terminating representation.
Question.
Yes, sir.
If the attorney would have had malpractice insurance, so wouldn't that have covered the defense costs?
If she did, yes, but some malpractice, of course, if there was malpractice and if that included grievances, some malpractice policies have that, some don't. So obviously that's a good thing to have. Yeah. So that's a good point to keep in mind. Now, the next case, the Bennett case, deals with a fact situation where a client hired me to represent him in a case involving two lawsuits. One was filed up in Amarillo, the second one was to be filed in federal court when the client was concerned about representation and his being followed by federal agents and wanted to know whether there's a freedom of information violation, whether there's a rule of privacy invasion, and paid $50,000 to handle these both cases. The short and long of this is that for 6 months the case proceeded. Every month the client was billed. The client became disenchanted with the case, wanted money back. There was a decision made to arbitrate that under the Houston Fee Dispute Resolution Committee, Houston Bar. And let me make an aside on that. In the contract that's in here that I wrote, there's a provision that deals with any dispute being mediated under arbitration rules with the Houston Bar Association Fee Dispute Resolution Committee. That case did go to arbitration. They ruled against me. We appealed it to the Court of Appeals, and we appealed it to the Texas Supreme Court. Ultimately, the client won, the amount was paid, but along the way, there was a grievance filed against me. And it's the bar's position that because I took the appeal, that in and of itself was a violation, okay? Now, the reason for that is that there's one phrase in the contract that says that resolution is unappealable, and you have to read this kind of carefully. The resolution is unappealable subject to the rules of the actual language in my contract was, by the signatures on this contract, the client Bennett agreed that the arbitrator's decision in such arbitration shall be binding, conclusive, and non-appealable pursuant to the rules and regulations of the Houston Bar Association Fee Dispute Committee. Please note that arbitration may result in the client's waiver of significant rights, such as the right to jury trial, possible waiver of broad discovery, and loss of right to appeal. So my language saying that it's pursuant to the rules of the Houston Bar Fee Dispute Resolution Committee was ignored by the state bar. They said just using the word non-appealable, you should not have appealed this case. Well, the problem with that is that under the Houston Fee Dispute Resolution Committee rules, Rule 8, which you have a copy of, it says that the arbitration will be under the Texas Arbitration Act. And under the Texas Arbitration Act, you have an absolute right to appeal. There's certain limitations on it. There's certain provisos about that, but you have a right to appeal. But that was the basis for the state, for the bar saying that I acted in an unprofessional way. The other thing about this case, which is sort of interesting, is on the appeal, we put up a cash bond of the amount in dispute with the clerk, and the client was ultimately paid, but that to the bar was not sufficient for them to dismiss the case. The case was tried in front of a juvenile court from San Antonio, a woman by the name of, gosh, my mind just slipped. I can't believe what.
Judge Carmen Kelsey.
Gosh, Judge Carmen Kelsey. Carmen Kelsey maybe I should have been a little bit more on my toes, had never tried a civil case in her life, nor did she ever try a disbarment case. One of my reasonings was that I had been assistant U.S. attorney in San Antonio for 3 years and brought over as one of my witnesses the former president of the San Antonio Bar Association, Dan Naranjo. Also brought Lillian Hardwick to testify. It's not a rules violation. And Judge Carmen Kelsey, said that she didn't need anybody to tell her what the rules were, and she refused to allow these experts to testify. Well, we made a pretty strong bill of exceptions, and that case is not on appeal. So those are some of the basics of what we're going to be talking about today, and the cases that hopefully from this you will be able to avoid similar problems. So we're dealing with how do you handle a client who does not want to pay you or you believe owes you money, the issue of whether or not you want an arbitration clause in your employment agreement. There's actually, and we included in the materials, a bar opinion number 580, dealing with what your rights are and what your responsibilities are if you include an arbitration agreement in your contract. And what that basically says about the arbitration agreement is that if you have the responsibility to make sure the client understands what the rules and regulations are in arbitration, what they're giving up. Now, what is also interesting about the Bennett case is that 3 times in the Bennett contract there are clauses that talk about, we advise you to have another attorney look at this contract and look at this fact situation. I recognize that this client may be rather difficult, and so I put that in. Not only did the client seek out another attorney, but the attorney he sought out was a former schoolmate of his in high school, an appellate judge by the name of Hollis Horton in Beaumont. And Mr. Horton Justice Horton wrote a letter saying, you know, I'm really not supposed to give opinions, but there's these contracts, and this is the way I guess they do business, and fine. So not only did he, was he advised to get an attorney, but the attorney he got was a sitting Court of Appeals justice. So the point for you in looking at whether any of this applies to a case that you have, applies to your contracts, applies to the way you want to do business, is that under the Rule 580 that deals with an arbitration agreement, it specifically says you have an obligation to inform the client about everything involved with a arbitration agreement, but it also says that it's not required for you to have the client I said 580, it's 586. It says specifically, consequently, the committee is of the opinion that Rule 108A does not apply to transaction establishing a lawyer-client relationship. In the committee's opinion, the establishment of a client-attorney relationship is not a business transaction with a client within the meaning of 1.08A. Consequently, the lawyer is not required by that rule to advise the client to seek independent counsel before agreeing to a binding arbitration clause and fee agreement. The American Bar Association ruling on this, or advisory opinion on this, is that if you're going to use an arbitration agreement, that you should have another attorney look that over and advise the client that what's going on with that. Our rules in Texas do not require that. I guess obviously to be on the safe side, you can put something in about recommending another attorney. Didn't help me that much, but you might be more fortunate after that. Okay. The other part that I want to talk about is responding to a grievance and what you should do when that happens. If you get a letter from the bar saying that a complaint has been filed against you, we all know now that the traditional grievance committees, as they function, no longer function that way. You can still get an evidentiary hearing in front of a bar committee, but the bar committees that made a decision that whether or not there was professional misconduct, that decision is now with the Office of Chief Disciplinary Counsel. So if a letter comes to you citing that a complaint has been filed and you need to respond, of course the first rule is always you got to respond to it. If you don't respond to it, that in and of itself is a grievance, and so you certainly don't want grievance upon grievance. And traditionally, the way that we've approached this is that we sort of go Katie bar the door and give as much as we can to the bar at this stage so that the chances of getting dismissed or kicked out from the process and ultimately dismissed is enhanced. And what I say about that, we've taken depositions, which you can do. We've gotten expert opinions, which you can do. Obviously, your file and documenting the contract, documenting correspondence, documenting why there wasn't a grievance, can all be sent at this stage to the bar. There's maybe a school of thought that says, well, if you give up all this information, are you giving them too much? And my theory has always been it's much better to get it dismissed at this stage than to have to go through the whole process of making a decision of whether you want to go through an evidentiary panel or go to a trial in front of a judge or in front of a jury, which is interesting because we're the only state in the United States that allows a jury trial in a disciplinary matter, which I think can have a lot of benefit, but it's only used in a very unique situation. Okay, so where are we now and what we've been talking about? In the materials that you have, the first part, and let me also say, this is sort of an aside, there's this little loose piece of paper that gives you information about a website, wrongful prosecution, judicial abuse of discretion, lack of evidence in commission for lawyer discipline grievance matters. And we've listed on this site about 12 different cases in the last 10 years of cases where there's been improper prosecution, the case has been dismissed, or an issue raised about what the prosecutor's done. There's been a Rule 13 violation, and so I think that's helpful to know how certain cases are being handled, okay? So that's just sort of an aside there for you to look at when you have the opportunity. Next, besides the cases, you'll see that Mr. Smitherman also has sent a letter about his position on the case. And what he included next to his letter, and I'm just going to run this real quickly, he included the arbitration agreement that you have a chance to look at, and what he did. Clarissa Guajardo and her decision is included there. Then the contract that was used in the Bennett case, the rules that apply to it, and then the bar opinions dealing with the rule violation. Okay, so what is the best approach when you're dealing with a dispute with a client? And I think we kind of summarize where we are with this by saying, first of all, even if it's a criminal case, and having been with the U.S. Attorney's Office and gone out and done criminal defense work, I even in a criminal defense case recommend a contract. I know that some people think, well, I get a flat fee, it's not required, it's not a contingency, I don't need a contract. But there's nothing better than to be able to say, I explained all this to my client, I explained to my client the plea agreement, I explained as I set forth in my contract, this is the 1-page, 2-page, I have a 17-page contract, maybe that's a little overkill, but and he signed or she signed that document. So I think that's very important to consider. I know that in criminal law, you're moving a lot quicker a lot of times, but that certainly is a strong recommendation. If you want to make an impact to the Office of Chief Disciplinary Counsel and show them that you tried to get the client informed, and the best way of doing that is to be sure that you have a contract. The second part of that is communication.